Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're continuing our two-part series about air passenger rights and a recent legal challenge to those air passenger protections. The challenge has been brought by the airline industry and a group of airlines. This March, the Supreme Court heard a legal challenge in the case called International Air Transport Association and the Canadian Transportation Agency. Today, we'll be discussing that legal challenge with two experts. Gabor Lukacs who is the president and founder of the not-profit Air Passenger Rights, and he was an intervener in this case. And we'll also be joined by John Gradek, a lecturer and program coordinator at McGill University. In the first part of this series, we discussed how air passenger protections work. In this episode, we'll be focusing on the legal challenge. John, Gabor, thank you both so much for joining me today. Let's start with who the people in this case are. Who exactly is the International Air Transport Association, Gabor? I know that this case is brought by them, brought by the airlines, some airlines themselves, but what can you tell me about this organization and its role in the airline industry?
So IATA claims to be regrouping of 290 airlines from 120 countries, carrying approximately 82% of the world's air traffic.
So it's a pretty big player. And John, what can you tell me about what exactly they are arguing at the Supreme Court? Basically they've said that these protections for passengers exceed the agency's authority and that they violate a specific treaty called the Montreal Convention. And so as a result of that, they say that it should be rendered invalid. What's your take on that argument?
Well, I think the argument has been one that IATA has been championing that argument for years. They've been trying to get that argument held in the European Union, and the European Union basically has stamped out that appeal on multiple occasions, and they're trying it in Canada. They're seeing if they can basically strike down these APPRs because of the fact there's a Montreal Convention that deals with the generalities of how should an airline handle passengers during a service interruption. And there's a minimum standard that is contained in the Montreal Convention that is very general in nature, that really has things like duty of care for passengers and not to leave passengers stranded, and to basically have a channel of communication. And they're saying, the airline is saying, or the IATA is saying, that's enough. We don't need anything more. And if you try to do anything more, that is what the APPRs in Canada are doing. It's in violation of the Montreal Convention, and therefore there's already a predetermined process that's governed by the Montreal Convention that supersedes the APPRs. And that is something that IATA is arguing. Now, the question is, Canadian APPRs are in fact going above and beyond the Montreal Convention. There's no doubt about that. But that's not, contravening the law. It's not contravening the convention. The convention sets a floor. How each individual country decides to implement further action to support passengers' rights for compensation is up to each country to decide. And I think that's where IATA is saying, that doesn't make any sense.
So the idea of the Montreal Convention is not a ceiling on compensation, but a floor. Gabor, is there anything you want to add to that about the role of the Montreal Convention and what the airlines and IATA here are claiming?
Yes, it's I think I need to kind of set the record straight, because the Montreal Convention does not provide for communication rights, does not provide for rebooking. It just deals with liability in the case of delay of passengers or a physical injury of passengers. What the airlines are saying is that under Article 29 of the Montreal Convention, it's exclusive. So once the Montreal Convention applies, then it preempts domestic law. There is some case law, to be clear, that stands for that proposition with respect to individual claims. So, for example, if you are being delayed on an international itinerary, then you cannot sue under provincial consumer protection law or breach of contract common law cause of action. You have to sue under the Montreal Convention if it falls within the scope of delay under the Montreal Convention.
Right.
But I agree with John, and that's what exactly my argument before the Supreme Court of Canada, that the Montreal Convention is the floor, not the ceiling, because airlines can waive
Okay.
defenses.
We've got to go to break, but we'll be right back.